Welcome back everybody to Public Law. As promised, this is going to be the lesson where we finally start to look specifically at the UK Constitution. We're going to take an overview of some of the most important aspects of the UK's constitutional setting. We'll take an overview of the sources of the UK Constitution, the structure of the UK government, as well as the different ways in which a change/amendment to the Constitution can be made. We'll also be comparing this, of course, and contrasting it to other constitutions which have differences in the ways in which they operate. We'll be talking about like I've said, the introduction to the sources of the UK Constitution, changing the Constitution, and the basic structure of the Constitution, imbuing one of the most interesting principles of the UK Constitution, which is this idea of the separation of powers. Now, these are all going to be, this lesson is going to essentially provide us a precursor to a far more in-depth series of lessons on each of these different topics. So we're going to talk in far more detail about the sources and the principles and the basic structure of the UK Constitution as we go on throughout the rest of this series on constitutional law. So, as a brief recap, we know the following things about the UK's constitutional framework. We know the following things to be true. We know that our constitution is, 1, uncodified. We know that it is a flexible constitution as a result of the fact that it is uncodified. We know that this is what brings in it with it this idea of flexibility versus rigidity, and contrasting that to the idea of codified constitutions, which are not flexible, which are rigid in their nature. We also know that it is somewhat of a unitary constitution. We note that this is contrasted with the idea of federalism and federal constitutions, where you have the separation of powers not just being horizontal but also being vertical between different areas and different levels of government. So the United States, for example, has a federal government which oversees the entire country. They then also have state governments which oversees the legal some of the legal issues in those particular states, and then they also have local governments. Now, the UK's constitution is far more unitary in the sense that the supreme source of authority and power, at least when it comes to the creation of new law, comes from the central government itself. It comes from Parliament through the principle of parliamentary sovereignty. However, given the fact that we now also have various different legislatures that exist at state levels, i.e. at country levels, when we have a look at the Scottish Parliament, the Welsh Assembly, the Northern Ireland Assembly, then there is this debate to be had about whether or not the UK is truly a unitary constitution, or whether it may be considered to be something of a quasi-federal constitution. It's federal in some senses, in that it looks quite federal. It looks like there are sort of different levels of government. But at the true heart of the UK's constitution, you still have this unitary centralisation of power. And we'll get to that in more detail when we look at devolution. So given the fact that the UK Constitution is uncodified, it is not written down in a single place, where is the UK's Constitution? Where can we find it? Well, because it's uncodified, not written down in a single place, it derives from a number of different sources. Where can we find it? Well, there are various different sources in which we can look at the UK Constitution. The first of which includes parliamentary statutes. So a piece of legislation that is passed by Parliament would therefore then contribute to the Constitution as a whole. Now, some people argue that it doesn't necessarily make sense to suggest that all pieces of parliamentary statute contribute to the UK Constitution, but only those pieces of statute that are particularly constitutional in nature. And there is a non-exhaustive list that we can cite that looks at the types of legislation which may be considered to be constitutional. Maybe legislation that refers to the structure of government, the way in which the government operates and proceeds, or maybe legislation that talks about and expresses the relationship between the government and the people. So things like the Human Rights Act, for example, is definitely considered to be a constitutional statute because it refers to the relationship that is had between the government, between the state, and between the people in terms of enshrining their rights in law. You also have things like the Constitutional Reform Act, which essentially moves which makes a very significant change to the role of the Lord Chancellor within the government system, and it also establishes the Supreme Court. So this is what is considered to be the distinction between constitutional parliamentary statutes and just general ordinary parliamentary statutes. But at least it is the case that one of the major sources of the UK Constitution is parliamentary statute in and of itself. A second major source of the UK Constitution is the common law that is made by judges, law that is made through cases and through various principles of precedent and stare decisis. There are a number of different generalized principles and ideas that are enshrined by the common law. There are also different principles and ideas which the common law utilizes to interpret parliamentary statute. So you will have lots of different examples of judicial review cases where the interpretation of a particular piece of legislation is put under scrutiny by the Court of Appeal or the Supreme Court and is examined in this regard. And this also contributes to a further understanding and a further deepening of the UK's constitutional setting, the result of which means that it contributes to a major source of the UK Constitution. We also have what are known as authoritative works, so works of authority. So these are often books, which are often quite old, in fact, which have which have a lot of authority in terms of the ways in which they explain and enshrine the different details of the UK's constitutional framework. So, for example, A.V. Dicey's Introduction to the Law of the Constitution from the 1800s is considered to be an authoritative work on the UK Constitution because it outlines and derives various principles pertaining to the rule of law and also pertaining to parliamentary sovereignty, all of which contributes to our understanding of the Constitution. If you want to look a little bit more at the internal workings of specific branches of the UK government, you might say that Erskine May is a very particularly authoritative work on the inner workings of Parliament and how parliamentary procedure operates. You then also have law of the European Union. I've put a little asterisk there because, of course, we are no longer members of the European Union. But before we left the European Union, the UK Constitution was quite heavily influenced by the various laws and principles which derived out of the EU, whether that be through the treaty law that existed within either the law in the European Union or the Treaty on the Functioning of the European Union, or whether it was the kind of secondary legislation, whether that be directives and regulations, for example, that contributes to the Constitution. These are considered to be the legal and particularly non-legal sources of the UK Constitution. A further non-legal source of the UK Constitution is known as a constitutional convention. Now, conventions are seen to be sort of the general rules of thumb which are followed by pretty much everybody, and they're sort of universally accepted as being binding despite the fact that they are not enforceable and despite the fact that sometimes people may actually violate various conventions. We will get to the process of how conventions are made, as well as the different principles and the different variations of the different conventions which exist when we look at that in more detail in future lessons' time. So given the fact that a constitution is made, the UK's constitution at least, is made from a number of different sources, what is the process by which you can make a change to the UK's constitution? Well, comparing this to the US system, for instance, we see that the process of the US constitutional amendment process is very difficult. We've noted already in previous lessons that it requires requires 2/3 majority in Congress, and then it requires 3/4 majority representation within the state legislatures, which is a significant amount of support for a particular amendment to be made to the US Constitution. This is why we say and suggest that the US's Constitution, is entrenched and it is very rigid. It is often very difficult to change. Hence why there has only ever been 27 amendments, and in fact there's only ever been 17 amendments after the Bill of Rights. Well, when it comes to the UK's constitution, making a change is very, very easy. There are three main ways in which you can make a change to the UK's constitution. You can change the law which is enacted by Parliament, i.e. Parliament will just be able to pass a new law which makes a fundamental change to the UK's constitution. Parliamentary legislation was important and vital to the process by which the United Kingdom leaves the European Union. And so as such, the EU Withdrawal Act, for example, from 2020, contributes significantly to a change in the UK's constitutional framework. In addition to this, Parliament could just as easily tomorrow leave the European Convention on Human Rights and revoke the Human Rights Act of 1998. Again, this could be done with a single vote, if there was a majority, of course, a single vote in Parliament, which would then remove those particular pieces of constitutional legislation, and the result of which is they changed the Constitution by that means. You may also have the passing of judicial decisions. The handing down of a judicial decision can make a change to the Constitution, either by making a change to specific judicial precedent or making a change by adding to judicial precedent, by adding to new circumstances and situations whereby a particular legal case has been brought. Again, this is another way in which the Constitution can change, and it can change particularly quickly. There is also the change in the existing practice of constitutional conventions. Again, we will get to this in more detail when we look at conventions and how new conventions form versus how old conventions sort of wither away over time, but that's one of the other ways in which we can make a fundamental change to the Constitution. Finally then, let's look at the basic structure of the UK's constitutional framework. We know that the UK constitution is structured in the following way. We have the legislature, we have the legislative branch. The legislature is the institution within government which is responsible for making and passing new laws, new statutes. These come from Parliament, Westminster Parliament, and Parliament is the supreme authority for the legislature in the United Kingdom. You then have the executive branch of government, which is responsible for the enforcement of new laws and is found in the UK government. So we often make a delineation between the UK government, specifically the executive branch being called the UK government, and the UK government more broadly, as in the entire structure of the system itself. So I'll try and be very clear when I make this delineation. But when we talk about the executive branch and the Prime Minister and the various ministers of state and the civil service, this is often also described as the government and the relationship between the government and Parliament, for example, even though you can also describe the UK government as the whole structure of Parliament, the courts, the executive, etc., etc., etc. So just a quick overview there of that delineation that is made. And then finally, you have the judiciary. The judiciary is responsible for the interpretation and the application of law. The most senior institution of which we find within the judiciary is the UK Supreme Court. Now, you might think that this is a particularly simple way of understanding the structure of the UK's constitution. This is a principle known as the separation of powers, the idea that various different powers are divided among each different branch of government so that no one branch becomes too powerful. So if you are the legislative branch, you shouldn't have the responsibility of making law, enforcing law, and then interpreting that same law that you have made, because then that can lead to situations of bias, and it can lead to situations where that one institution becomes too powerful. However, when we look at the UK's system of separation of powers, we will note that it's a little bit more complicated than as described here. Even though there are three distinct branches within the UK system, we do have a legislature, we do have an executive, and we do have a judiciary. They're not so separate in the same way as, for example, the United States system may be completely separate. And we'll get to that when we start looking at the various principles of the UK Constitution. Now that we've explored the nature of the UK's constitution in a little bit more detail, it's important that we have a better understanding of its history, because the way the constitution has developed is, of course, a product of its history, in the same way that the way the US Constitution developed is a product of its history. The Revolutionary Wars, the American Independence Declaration, and the various different meetings in the Continental Congress to establish the US Constitution and the Bill of Rights. In a similar way, in a similar vein, the UK's constitution is as much a product of its history as any other constitutional framework. And given the unique nature of the UK constitution, it signifies the unique nature of the history of England and the history of the United Kingdom. So that's what we're going to do in this lesson in a very unbelievably brief manner. Essentially, what we're going to do is talk about the UK's historical development of its constitution. And while a history of the UK Constitution is far too detailed a conversation to be having in this particular series, we're going to just take a brief overview to look at some of the major implications of it. We'll also talk about the history of the UK Constitution in other contexts as well in the future. So, for example, when we look at the development of parliamentary sovereignty, the impact of the Glorious Revolution, and all these different things, that's going to be something of a historical debate as well. And we're also, of course, going to be talking about the history of the UK Constitution in a separate series of lessons specifically on that topic. For our understanding today, however, it is important that we look at the broader historical context in which we can conceptualize our Constitution and the development of our Constitution, which is the purpose of this series. So, given its early history, we're not going to spend too much time looking at it because the main events that we see will take place a little bit later on during the events of the tumultuous years of the Stuart dynasty and the development of the Glorious Revolution. But in terms of the early history, we can say that the English legal system can be said to have its beginnings within the sort of general period of the Anglo-Saxons and the development of the Anglo-Saxon period, the heptarchy, which then develops into a unified England under the reign of King Athelstan, who is the grandson of Alfred the Great. But it is also the influence of the Roman law, which plays into the modern conceptions of the development of the UK's legal system. And in addition to this, the groundworks for what eventually becomes known as the common law, the development of the common law system, is found in the 1066 Norman invasion, the establishment of the Norman England and the new Norman kings, which come after this period of Anglo-Saxon Britain. So this is eventually what would ultimately turn into the development of the common law. The common law would also develop through the system of, or at least through the dynasty of the Angevin kings and the Angevin dynasty as well, and the Angevin Empire. But for now, we'll just talk a little bit about the groundworks from the Norman invasion. The entire constitutional history of England could even be described as a history of the relationship between the crown and the people being a generalized term here, not just representing everyone within society, but in some circumstances representing people in terms of the nobility or specific members of the nobility itself, beginning first with 1215 and Magna Carta. So sometimes referred to as the Great Charter, Magna Carta was a settlement which was agreed upon by the king of the day at the time, who was King John of England. And while it is considered one of the earliest documents outlining the relationships between the king and the people, it's a little bit oversimplistic and to an extent inaccurate to make the argument that it is a relationship between the king and the people, in the sense that we're talking about the general population at the time. Rather, it was the outlining of the powers and the limitation of powers that the king had and that was subjected to with reference to his barons, so specific individuals within the nobility of England. So there was this huge class divide, which would continue and does continue in some extent to this day, between the lower classes within society and the higher classes, the members of the nobility within society as well. So this is what Magna Carta essentially does. It outlines some of the limitations of the powers that the king has over and subjected to and over his barons. He was essentially forced to agree to the Magna Carta. No one signed the Magna Carta for a start. It was agreed upon. And even when King John dies, his son Henry III would reissue the charter, keeping some of the most fundamental provisions. Now, to this day, the provisions which were taken out and added in have changed quite significantly over the years. But since King John, the Magna Carta has been an accepted practice throughout the early period of the sort of medieval kings within England, and continues to this day in some regards. but it is mostly considered to be a historical document. That is one of the things that is important about Magna Carta, that it is a historical document which influenced a number of documents subsequent to it, including international documents. So things like the US Declaration of Independence, the US Constitution is somewhat influenced by Magna Carta. The ways in which the French Revolution operated within the 1700s also is somewhat influenced by the Magna Carta, as well as a number of Enlightenment ideas as well. Now, skipping ahead quite significantly, we're going to make a major jump from the 1200s to the 1600s when we talk about the major constitutional crisis which takes place in the 17th century. This was following the English Civil Wars, as well as the monarchical attacks on Parliament, the regicide of King Charles I, the execution of King Charles I, and various numerous constitutional changes which took place and were made in this process. So the constitutional crisis of the 17th century was as much a development pertaining to the relationship between the king and parliament as anything else. And the relationship between the king and parliament had been strained and was continuing to be strained following the end of the Tudor period, following the end of the Tudor dynasty in 1603, going into the reigns of James I and then Charles I, specifically within the idea of taxation. It was considered to be historically the remit of Parliament to issue taxation, even though for the most part Parliament would just follow the will of the monarch in being able to issue taxation at that period. But where Parliament refused to issue further taxation and Charles began to circumvent parliamentary process, we start to see more and more tension develop between the two, which causes an outbreak of the English Civil War, which the parliamentarians ultimately win. King Charles ultimately loses, and then we get the trial of King Charles I, and we get the execution of Charles I. The first instance in the English history where we see the execution of a monarch in this kind of way. Now, despite the fact that the revolution and the Civil War took place during this period, it did not lead to a formal and long-lasting settlement with a constitutional document being written up. There was something of a constitution developed during the period of the Republic within Britain, which didn't last particularly very long under Oliver Cromwell as the sort of leader, which was a kind of de facto monarchical position. And the reason for this was because, of course, we see a restoration of the monarchy in the 17th century. We see King Charles II take over. We then see the fact that because King Charles II was Catholic, and this clashed quite significantly with the Church of England, we see the parliamentarians, the members of Parliament, inviting William of Orange over to rule as the new King of Britain, which would then instigate the Glorious Revolution of 1688 and the subsequent Bill of Rights of 1689. But it is quite interesting that where we see revolutions and civil wars take place, not quite during the 17th century, but more the 18th century, we see that formal documentarian constitutions are established. So things like the U.S. 1776, we see the Revolutionary War, and we see the Declaration of Independence, which leads into the U.S. Constitution. We see constitutions formally being drawn up in France following the French Revolution. We see a constitution, or eventually, at least anyway, we see constitutions being drawn up after the German Revolution of 1918, establishing the Weimar dynasty. But this same kind of constitution being drawn up didn't happen in the 17th century. It didn't happen in England. So one of the reasons why this was the case was because in terms of the American Revolution or the French Revolution, the English Revolution and the English Civil Wars didn't technically work in terms of what their goals were ultimately to achieve, which was to overthrow monarchy and to establish a republic. They established a republic for a very brief period, but then the monarchy would ultimately be restored. This is unlike the case of the US, for example, where the monarchy was never restored. We never went back to the English monarchy in the United States, and so the result of which was we didn't have this formal, long-lasting constitutional document being written up. The power of the Crown over Parliament would be formally relegated with the Glorious Revolution of 1688 and then the subsequent Bill of Rights of 1689. When we talk about the principle of parliamentary sovereignty in future lessons, we will talk about the impact of the Glorious Revolution and the Bill of Rights as the influence for the principle that Parliament is the supreme lawmaking authority within England and Wales, within the UK even more formally. So, essentially, these events solidified the principle that when it comes to lawmaking, the Crown is subordinate to Parliament and the people. We're going to take another jump. We're going to go from the 17th century to the early 20th century, where we see further democratization take place during this period. This is influenced by, significantly, the Parliament Act of 1911 and the Parliament Act of 1949. These both represented a further increase in the influence of democracy, specifically within the internal workings of the parliamentary process. So, given the fact that we have a bicameral legislature in the United Kingdom, where we have two chambers within Parliament, we have the unelected upper house, which is the House of Lords, and we have the elected lower house, which is the House of Commons. What the Parliament Acts do from 1911 and the one in 1949 as well is limit the power of the House of Lords quite significantly. And this is also done through constitutional convention, so things like the Salisbury Convention add to this as well. But essentially it codifies the principle that the House of Commons, because of its democratic legitimacy, because of the fact that it is accountable to the people, because of the fact that it is not appointed, it is elected, is now superior to the House of Lords. And this superiority exists and continues to exist in Parliament to this day. Finally, then, let's talk about the end of the 20th century, going into the beginning of the 21st century, which is, of course, the New Labour constitutional reforms. The era of New Labour in 1997 would introduce some of the most major constitutional reforms, which have significantly shaped the way the Constitution operates to this day. You have devolution legislation establishing a Scottish Parliament, a Welsh Assembly and a Northern Ireland Assembly, quite significant in terms of the ability for Westminster to delegate authority to those particular institutions. You have the Human Rights Act of 1998, which formally brings the provisions of the European Convention on Human Rights into the UK's constitutional framework and provides a significant process by which you can challenge the government for potential human rights violations. You also have the Constitutional Reform Act of 2005, which made a number of different changes to the role of the Lord Chancellor, which we'll get to in future lessons' time, and it also establishes a Supreme Court, which moves essentially the same individuals, the law lords, out of the House of Lords, across the square, into the old Middlesex building, and establishes a new Supreme Court. In 1999, you also have the House of Lords Act, which removes a number of the hereditary peers, all but, I believe, 74 or 92, I want to say 92, hereditary peers are removed out of the House of Lords. Of course, the idea of hereditary peerage is something of a very antiquated and outdated process and system. The idea that you are born into a family which automatically assumes that you have the ability to obtain a peerage in the House of Lords seems quite, like I said, antiquated and a quite significantly outdated idea, and so as a result of that, the House of Lords Act removes a number of the hereditary peers from the House of Lords, creating quite significant constitutional reforms that were enshrined and established by New Labour from 1997. Welcome back, everybody, to Public Law. In this lesson, we're going to talk about the structure of the UK's government. This is going to be an overview lesson for us to get a better understanding of the various different institutions and processes that we're going to be exploring as we carry on exploring and examining the UK's constitutional framework and UK constitutional law more generally. So we're going to take a formal look at the structure of the UK government. We're going to talk about the concept of the separation of powers. We're going to examine Parliament. We're going to examine Parliament as a bicameral legislature and the principle of bicameralism within the parliamentary process. We will talk about the role of the Crown and the royal prerogative in brief detail as well, before we talk about the executive, the government itself, the Prime Minister, the role of the executive and the cabinet, And then finally, we'll talk about the broader executive, which is sometimes described as the civil service. So the concept of the separation of powers is something that we will explore as time goes on in more detail when we look at the principles of the UK Constitution. But within the broader corpus of constitutional theory, this is a very liberal idea which derives again out of the Enlightenment and a number of different Enlightenment thinkers. And it's the idea and the concept that what really ought to be the case is that power should be separated between the various different institutions of government. And the reason for this is to ensure that no one person, or as more likely the case in some circumstances, no one institution becomes too powerful, and as a result of which could establish itself as a formal dictatorship or totalitarian state, all of which would not be great for the concept of the separation of powers and the concept of democracy. And so as a result of this, many constitutional frameworks around the world opt to establish this idea of a separation of powers, and power is usually in this context divided into three modern concepts within the constitutional framework. You often have a legislature, an executive branch, and a judicial branch. And the reason for this is so to ensure that these are the three kinds of authorities, the three kinds of powers that government has within a constitutional setting, and so as a result of which they are separate and should be divided amongst themselves, such that no one institution has the ability to have legislative, executive, and judicial power all at the same time. So what do these things actually mean? Well, when we talk about the legislature and legislative power, the concept of legislative power relates to the idea of passing law, the idea of making law and making legislation. So in the UK's constitutional framework, the remit of this is obviously done through Parliament. Parliament has the authority, the sole authority in fact, to make and pass law. The executive branch is responsible for the enforcement of law, and the executive branch exists in the form of the UK's government, the executive branch itself, so the Prime Minister, government ministers, etc., 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 as well as the civil service more broadly. The judiciary is of course situated and housed within the various judges and courts that exist in the UK's constitutional setting, the highest of which being of course the UK Supreme Court. There are various other courts of appeal that exist as well within this process, and the judiciary is responsible for the interpretation and the application of the law. They apply the law to facts, they interpret legal precedent, they interpret legislation that has been passed by Parliament. So the idea here is that the concept of the separation of powers instills the fact that those who make law should not also be the people who enforce the law and then also interpret and apply the law. They should be separate. And in the UK's constitutional framework, we will see in future lessons' time that the separation of powers is relatively limited in the sense that we have a fusion of the legislature and the executive branches of government, and the judiciary is only separate to the extent to which there has been a separation formally with the establishment of the Supreme Court in 2009. But that there were also institutions and offices which branched all three of these different distinct branches of government. For example, the role of the Lord Chancellor had significant authority in all three, in fact, in the legislature, the executive, and the judiciary. He was the head of the judiciary, he was a speaker in the House of Lords, and he also sat in the cabinet, making him a member of the executive branch. Of course, this is a stark contrast and a stark violation, if you will, of the concept of the separation of powers. So this contrasts, in fact, to the formal jurisdiction and the formal separation of powers which can be enshrined in various different codified constitutions. One notable example of this is, of course, the United States. The United States has a codified constitution which clearly sets out the powers of each of the branches of government, as well as this sets out the authority and power that one branch of government has over the other branches of government. This is known as a system of checks and balances. The way here is that not only is power separated across these three institutions, and the institutions are clearly separate, but in addition to this, the institutions can also have power over each other, such that no one authority can have too much power because it can be checked by the other two branches. There are various examples of how this works in the United States. For example, the legislature, the Congress, has the ability and the power to make law, to make legislation, but the president has the power to veto that legislation. And so that is representative of a check that the president has over the Congress, over the legislature. But then, as a representation of the check that Congress has over the president, if the president vetoes a piece of legislation, then Congress can actually override that veto if they have enough votes. And so you can see there, just in one process, the process of passing law, that there are multiple checks on both from both situations in terms of branches of government. In addition to that, the Supreme Court in the United States has the power to check the legislature as well, because it has the power to strike down any law that is unconstitutional. So if Congress passes a law that is unconstitutional, then the Supreme Court can say, no, this law doesn't exist. This law is wrong, it's unconstitutional, it is no longer enforced. So these are the various ways in which checks and balances can be enshrined within the US system. Compare that then to the UK's system of separation of powers, where we have a significant limitation. Before the implementation of the Constitutional Reform Act, the 2005 Constitutional Reform Act, before it was formally implemented, i.e. the Supreme Court was opened in 2009, all three branches of governments sat in Parliament. The highest judicial office was the Lord of Appeal in Ordinary, which sat in the House of Lords, the Law Lords. The Supreme Court obviously changes this, formally separating those two institutions. They go across the square, and they now sit in the old Middlesex Hall opposite Parliament. The aim here is, of course, to show representatively a clear separation of powers, some clear blue water between Parliament, the legislature, and the Supreme Court, the judiciary. But when it comes to the executive branch sits in the House of Commons and is derived out of the legislature. The government is made up of members of Parliament. They have constituencies who they represent. They have a vote in the passing of laws through Parliament. And so as a result of which you have not a separation of powers between the legislature and the executive, but you have a fusion of powers. Now, ultimately, Parliament does have the authority, and one of the major roles of Parliament within the UK's constitutional framework is to essentially check and hold the government to account. But they do so from inside the House of Commons, from inside Parliament itself. So ultimately, let's think about the structure of Parliament then. Parliament is what we describe as a bicameral legislature. What does this mean? Well, it means that it is divided into two chambers. You have the House of Commons and you have the House of Lords. Similar to other legislatures in other parts of the world, again, I refer to the United States. The US legislature is, of course, Congress, at least at the federal level, and Congress has two chambers as well. It has the House of Representatives, and then it has the Senate. You can have situations where there are three chambers, something known as a tricameral legislature. I believe Spain, for example, their legislative branch has a tricameral legislature, or it might be Italy, or maybe both. But there are multiple different ways in which you can structure legislative branches. You can have some institutions that are unicameral, which have just a single chamber in which law is passed. Within this whole process, the Crown exists as a very interesting power and a very interesting check, because ultimately the United Kingdom's constitution is a monarchical one. It is a constitutional monarchy. What this means is we have monarchical authority, we have a monarchy which still plays a significant role in the administration of government, but that the monarchy is limited by the constitution. And this is, of course, owing to the historical relationship that the monarch has had with Parliament, as well as the sort of tumultuous years under the Stuart dynasty, the restoration of the monarchy, the limited restoration of the monarchy with the Glorious Revolution of 1688. But regardless of all of this, the Crown still plays a significant role in the administration of government. The exclusive powers which are conferred to the Crown in their authority as monarch are known as the royal prerogative. We're going to get to the royal prerogative in more detail when we examine the sources of the UK Constitution. But by constitutional convention, what we see here is that the powers of the prerogative are actually conferred not onto the monarch per se, but to members of the executive, who are then accountable to Parliament. So we sort of see how, on paper and in theory, the monarch is still severely powerful in terms of their ability to do things, in terms of their authority within the constitutional framework. This is done through the royal prerogative, but by way of constitutional convention, the powers of the prerogative are conferred onto members of the executive, who are elected members of parliament, but who are also accountable to parliament as well. And so this sort of plays a role as a democratic process, and it's almost a self-regulating democratic process by which the powers of the crown still technically exist, but are limited by the powers of parliament. The monarch will still act on the advice of the prime minister and the advice by the government by way of convention. They cannot act on any other advice. They cannot take any other advice outside of the advice of government. This is also a constitutional convention. And like I've said, we will get to the details of the prerogative in future lessons' time in far more detail as we go on. Speaking of the government, let's think about the executive branch. The executive branch of the UK government is also confusingly described as the government. When we look at the House of Commons, for example, we make a delineation between the government and Parliament. And when we talk about the government in that context, we're talking about the executive branch. We're talking about the Prime Minister, we're talking about the various other ministers of states, the various other departments of state, and if we're going to go even further, we're talking about the civil service and various members of the civil service as well. But obviously, when we talk about the government as in the UK government, we can also be referring to just the whole picture, the whole holistic understanding of judiciary, the legislature, parliament, number 10 Downing Street, the prime minister, everybody. But when we talk about the executive branch, we're talking about a specific institution within government that we also call the government. The government has the responsibility for drafting and implementing laws, as well as drafting and implementing policy within the United Kingdom. Ultimately, the executive is usually formed when a political party wins a majority of the seats in Parliament. So when a general election is called and a general election happens, there will be a party that often wins a majority, owing to our first-past-the-post electoral system. It's supposed to give us majorities, but not always. Ultimately, we get a majority in Parliament, and then the Crown, by convention, invites the leader of that political party to form a government in their name. This isn't always the case. Of course, you have circumstances where there is not a single party with a majority. This is sometimes known as a hung parliament. The result of this is, of course, the fact that when you have multiple different parties all vying for power, and you don't just have a dual party system, then it is more likely that you're going to have hung parliaments and no single majority. Because given the fact that in the United Kingdom, you have the Conservative Party and the Labour Party, which sort of come out as strikingly the two most popular parties, but then you also have the Scottish National Party, the Liberal Democrats, you have the Greens, and you have, in previous elections, you had parties such as UKIP, etc., all of which vying for power and authority means that that takes votes away from the two larger parties, meaning that it's less likely to get a single majority. Compare this again to the United States, where de facto they have a two-party system. There are other parties that are allowed to run, but they don't get a look in. For the most part, you are either going to vote for the Republicans or you're going to vote for the Democrats. So ultimately, when you have a hung parliament, multiple parties may come together and form a government collectively. This is sometimes known as a coalition government. The last time we saw this was in 2010, between 2010 and 2015, when the Conservative Party under David Cameron teamed up with the Liberal Democrats under Nick Clegg to form a coalition government. Finally, then, we have the civil service. Now, the civil service is sort of described as the structural components of the executive branch. The reason for this, of course, is because when you talk about the implementation of policy and the enforcement of law and all of these different complicated issues, you need a very big and vast network of individuals who will work to do the running of the day-to-day implementation of government policy. So the civil service is responsible for a great variety of different tasks, from the very high level tasks such as contributing to the drafting and the creation of legislation, to some of the smaller tasks such as the paying of benefits and pensions, or the issuing of student loans. That's a civil service task that those of you who are at university studying law at the moment will obviously be familiar with, the issuance of student loans and tuition fees and things like that, the running of prisons, as well as the issuing of driving licenses. Everything from the drafting of legislation to the issuing of student loans to the issuing of driving licenses are all things done under the remit of the executive branch, i.e. under the remit of the UK civil service.